I have submitted a volume 3, small compilation. Lordship need not open it, Lordship just note, if Lordship doesn't mind. That is about how spouse is understood in section 5.1.
There's something called annexure 3.
Annexure 3. Compilation.
I don't know.
Compilation 3.
Circulated last night.
Volume?
Volume 3.
Volume 3.
105 pages, right?
Volume 1, Volume
Yes.
2, amended written submissions.
Amended.
Yes,
Annexure
yes,
2.
compilation
Annexure
volume
2?
3 is there.
Is it
Say-
annexure 2?
Compilation volume 3.
Ah, yes, compilation volume 3.
At
है,
page-
वहीं पर है, उसके नीचे है.
Volume 3, yes.
What is the
PDF
page?
PDF 161.
205.
Pages?
205 pages.
161.
Got it.
Lalita Gupta.
Yeah.
159.
Is that 2011 or
Yes,
2012?
that's right.
Justice Kajju, I think.
This is
You said PDF 161, which is actually a judgment called
Lalita Gupta.
Leela Gupta.
Leela
Gupta
Gupta.
versus Lakshmi Narayan,
Leela Gupta, at paragraph 13.
para 13.
My
Yes,
Lord Justice Bhat has it.
I'm just trying to-
160.
Is it
If
PDF
Lord will come,
161?
PDF.
my Lord Justice Kohli has it.
59.
Put it to 161.
Got it? हाँ भैया
Yeah.
मिला आपको?
Just above para 14,
Yes.
6 lines. The word spouse has been understood to connote a husband or a wife, which term itself postulates a subsisting marriage. The word spouse in subsection 1 of 5 cannot be interpreted to mean a former spouse, because even after divorce, when a second marriage is contracted, if the former spouse is living, that would not prohibit the parties from contracting the marriage. So only emphasizing this word spouse, my lords.
All right.
Although
What
that
else?
is apparent, my lord, this is one judgment which my learned colleague could find out. my lords, on
All right.
this.
What else?
Now, my lords, on the issue of originalism also, this is not in the compilation, my lords. In 2017, 12 SCC, page 1, Jindal Stainless,
Yes.
para 184 and 202,
Would you repeat it, please? 2000.
2017,
Yes.
volume 12 SCC, page 1, Jindal Stainless, para 184 and 202,
On original interpretation.
on, my lord, the entitlement of the court, my lord, to look into, or rather necessity to look into the Constituent Assembly debates. There are large number of judgments, but this is 9 judges,
right.
so, my lord, I just picked this out.
Not necessary to read it.
Not
we'll just
necessary.
take it. Yes.
Because n number of judgments are there, not where your lordships have looked into this.
Oh, yes.
Of course, brother, I don't mean to say, Lord, that
But
things
they're
are
binding
frozen.
on things, yes.
That's not the contention. The contention is what I wanted is, Lord, that
Must
what
be-
are those circumstances, what are those limits, Lord, on ignoring, Lord, so there has to be something really
All right.
fundamental, Lord, which has an
Right.
impact. on
Point
that.
is taken. Yes.
That's the
All right. What is the next point now?
Then coming back to the written note, Lords,
Final written submission.
yes, final written submission.
Yes. Finally.
At page 9, there were 3 cases, my lord, which Mr. Viswanathan cited. Well, I will find these 3 cases I've dealt with, my lords, and D.S. Nakara, my lords, and Vishnu Das. They were both on, my lords, administrative orders.
Cut off date.
So it had nothing to do with a legislative enactment or a constitutional provision. So reading in or reading up and down, all those principles were not involved. Cutoff date was struck down in Nakara's case. And Vishnu Das, there was it's a transport matter, was a scheme found discriminating was struck down. And in association of old settlers also, it was a case of striking down some portion so that old settlers could also be accommodated. In none of these cases, not anything was read into any enactment, that too of a substantial nature, as is sought here. On Ghedan, my lords, much has been said. By the learned Solicitor General, all of which I adopt, my lords. If your lordship turns to page 14, kindly just note, Lord, that in Ghedan, my lord, I have extracted here, the Secretary of Council for the Secretary of State had conceded. And in the light of, Lord, amendments which were already before the House for permitting same-sex partnerships. And Para 128, Lord Roger has recorded that. He records, certainly Council for Secretary of State who made submissions in favor of interpreting Para 2.2 in this way did not foresee any such problems in reading like that.
Where are you reading that, Mr.?
Page 11, I think, page 10.
Clause D at the bottom of page 14.
Yes.
Third line. He records, certainly Council for Secretary of State who made submissions in favor of interpreting Para 2.2 in this way did not foresee any such problems. It is also notable that by the time this judgment was delivered on 21/604, the bill relating to civil unions was already under consideration and ultimately received royal assent in December 2004. So these were the circumstances in which, and that too was a minor change which was done. But what is more important, you shall find in F. In MacDonald observed as below, if the court implies words that are consistent with the scheme of legislation but necessary to make it compatible with convention right, it is simply performing the duty which Parliament has imposed on it and on others. So it was a parliamentary act which required the court to make it compatible and tell the House. It is actually, this is an advisory jurisdiction because as the Lordship saw in section 3, which I have quoted at page 12 and 13, kindly at page 13, subsection 6.
Yes.
A declaration under this section does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. So this is a very peculiar, it's not a provision of judicial review at all. It's more like an advisory jurisdiction, number
What's the
43,
next point, Mr. Dwivedi?
which separation of powers then
All right.
in fact, after the court has given the judgment in Kedan, Parliament is quite competent to take another view by passing an amendment.
All right.
Now, so far as separation of powers is all well settled, my lords, and I will only request the lordships to note the judgment at page 19. This is, my lord, the Chief Justice's judgment, my lord. I'm sorry, my lord, the word J is missing there.
Page 19.
Satpal Saini.
Yes.
Para 12 particularly, the lordships have said that each branch is equal, and there should be no encroachment. The courts do not frame policy or mandate that particular policy should be followed. Duty to formulate policies entrusted to the executive. Whose accountability is to the legislature and through it to the people. The peril of adopting an incorrect policy lies in the democratic accountability of the people. That's para 12, at page 20. One interesting feature, my lord, to be noted is about separation of power is Article 50. If your lordship looks at it, for a second. It talks of, that's the Constitution of India, Article 50.
Separation of the executive, judicial.
What do you want us to look at, Mr.?
Article 50 in the Constitution of India, separation of powers. Hello, Justice Kaul has, Manoj?
Yes, yes, please.
50-50.
50, 50.
Separation of judiciary.
Oh, yes.
The state shall take steps to separate the judiciary from the executive in the public services of the state. It doesn't talk about parliament, my lord. Now, there is significance, my lord, because I have quoted a number of articles where, my lord, parliament has in the judicial domain power to make laws, my lords. At page 21, your lordship will find in bold.
You know, actually, Article 50 was enacted in a different context, because actually, even after the Constitution, until recently, there was no strict separation between the executive and the judicial functions, especially in the district judiciary. The idea was to ensure that, you know, the district magistrates, for instance, don't exercise the powers of a civil court. Even today, until
There are some
recently, in the
places
Northeast, for instance,
Even today.
even today,
Fruits of,
Commissioners and all that. kind.
If you could have a, if you
But
could have a
I have not drawn the lordship's attention to say that this is something decisive about the range of the manner.
broadly the
But
drift.
because separation of powers is to be deciphered by referring to all
the-
provisions
the
of the
best exposition
scheme of the
is in
Constitution.
Indira Gandhi, is in
Yes.
Indira Gandhi.
Yes.
What is separation of powers in
Yes.
India?
So,
All right,
entirety of the
let's,
Constitution
let
has to be read.
So Dwivedi, this is very well settled. I think
Yes,
we can
yes.
move on to the next
Yes.
point.
No. What is good? Kindly, my lords, just note, my lords, three cases at page 24 and 25, where writ petitions demanding a common civil code, your lordship said it is for legislature. Then Hindu Adoption and Maintenance Act, your lordship says areas and aspects or facets of Hindu law which require modernization, modification, alternate are matters of legislative policy. That is 24 bottom, and then at page 25.
of your note.
Yeah,
Then read it.
Udesh, Maharishi.
Page 24 bottom,
Got it, got it.
and running to page 25. There are three judgments where in the field of reforms, social reforms, your lordship said that it is for the legislature. The last one, my lord, is an order, my lords, in writ petition number 319, which wanted the court to intervene with regard to dowry menace and so on. Your lordship said legislature.
All right.
Then next page, I'm not reading, my lordship, some foreign judgments are mentioned in the same direction.
Same-sex marriage. 29 onwards.
If your lordship comes to page 29, this is in the same sex context, my lords. Oh, okay. This Obergefell, my lord, of course, is there, but we have quoted there also at page 26, 27. Just take the same view, and if you lordship recollect, they only issued a declaration leaving it to the. Oh, that's. Then page 29 is Shoot Attorney General of Michigan versus Coalition to Defend.
Right.
We are the same, my lords. And 32 is Israel, where a foreign marriage, my lord, was the issue to be, it was not being registered in Israel. Para 33 is Panama, my lords, and it also mentions Thailand. These judgments are there in my compilation, lords. I'm not reading, it's all in the same direction. Interestingly, Panama is very close to America, my lord, yet discordant note. Now, kindly come, my lord, then I come to Article 14. Because the first question is there a fundamental right, my lords, for persons in same-sex relations to marry, my lords, either flowing from Article 14, 15, or 21?
Mr. Dwivedi, apropos a discussion which we were conducting between the three of us and my learned sister, does anyone have a fundamental right to marry?
But since certain judgments
Forget the issue of same sex.
yes,
Does anyone have a fundamental right to marry? Or is there no fundamental right to marry at all, according to you? Because your submission is that no one has a fundamental right to marry. Or is it, what is your answer to this?
my submission is simply this, my lord, that so far as heterosexual
No, we are
marriages-
not on heterosexual.
That's why keep
We
aside
we
this.
see that's what
Concept
actually
of marriage.
triggered this idea.
Yeah.
yes,
Does any citizen of this country for whom this court and our society and our polity has placed the individual at that highest pinnacle, and we have gone ahead and carved out, or rather discovered, so many rights: the right to personhood, the right of choice, the right of being left alone, the right of
Autonomy.
privacy, autonomy, which is at the core of personhood,
And dignity above all.
dignity, which is part of our preambular promise.
yes.
Now, with all this, what is the question? The core question is, does a citizen or a person have a right to marry? Is it part of 21 or it is not part of 21? Granted that, but that in that sense, there is no unqualified right. We have to start with the premise that there is no unqualified right. The right to free speech is not unqualified. The right to association is not unqualified. Personal liberties are not unqualified.
Right to life itself is not
Right to life
qualified.
is not
It can be
unqualified.
taken away on a
Therefore, we
conviction.
don't start with there is no unqualified right. There is no absolute right. If you start with that premise, what is the right? Does the right to life have that concomitant of the right to marry? So do not start the debate with whether same-sex people have the right to marry. Rather, what is the right to marry? Is there a right to marry?
So my submission is that the heterosexual couples have a right to marry in accordance with their custom, personal law, and religion, and that has been continuing. That's the foundation of their right. Now that right has been
So, but therefore you concede the fact that therefore there is a right to marry under the Constitution, but that right to marry is confined only to heterosexual persons, according to you. Or is it your argument that there is no right to marry at all as a fundamental right under
I'm
the
saying there is a right to marry which is founded on customs, personal law, and religion. The
And in
enactments
that case,
passed,
as you taking the same argument further,
yes,
custom, culture, religion. Rewind 50 years ago, intercaste marriages were not permitted. Even go back further, Sapinda marriages were not permitted, right?
So there-
Interfaith marriages were unheard of,
yes.
right? So all this, the content of marriage has changed. Therefore, what was that fundamental right to marriage in
So
1954?
these
Or
change-
core content.
these changes therefore have been brought about by legislation, and legislature can certainly alter the customs, and now the ghost of Narasimha has been
Maybe keeping aside for a moment the legislative aspect, as you said, it's the culture, it's
Yes.
the customs that has brought about this whole matrimonial setup. Keeping that legislation aside, would you say that you're referring to the relevant articles of the Constitution? Is it that it is based and founded in the Constitution, the right to marry? Is the question.
So the Constitution only gives a fundamental right to form relations, associations, which is there in 19(1)(c), which can be regulated.
Persons.
Now, what we call our association as marriage has ultimately, over the course of years, resulted in a social institution. It's not an overnight something happening, Millard, and two people coming together and say, call it marriage. So it's a long period of time where this institution of marriage has emerged, and as a result of society's evolution.
So even prior to the Constitution,
Yes,
there was this whole customs, ceremonies,
absolutely.
and all of it.
Yes.
Once the Constitution came in, is it your argument that the marriage was
So that right to
Correct.
marriage, which was existing as a part of social institution, will be accommodated in the right to associate in a particular manner and in a particular social institution. Asking to open the doors of this social institution of marriage as existing for them. And that's the plea, that we stand at par for various reasons and therefore make the amendments in the SMA. SMA has now become unconstitutional, violative of Article 14. It may not have been violative of Article 14 in 1954-56 when a cluster of laws were
By
codified.
the same token, Mr. Dwivedi, Constitution has not granted anything. Go by the theory of the dissent in the habeas corpus, or even by what is generally accepted. It only recognizes and guarantees. Nothing is granted. We are free citizens. We have taken this onto ourselves. So the right to speak, the right to associate, everything is part of our inherent rights.
That's right.
Constitution,
Yes.
therefore, does not grant.
It-
So even the legislations have only recognized. So that right to marry is inherent. If we say the right to marry is inherent, it is part of the Constitution. You may locate it in 19, you may locate it in 21, perhaps appropriately 21. Because 19(1)(c), the history you see brought was in terms of association, as we understand.
So it doesn't matter where it is located or taking together, it is located somewhere along with the preamble.
As we normally define a natural right.
That's right.
But the right to marriage in the sense in which
This is the problem. The moment we qualify it in the sense, because
That's important.
when you bring in the tradition, now the Constitution itself is a tradition breaker. The Constitution is a tradition breaker because for the first time you brought in 14. If so, let me
I
just come.
appreciate.
If you brought in 14, if you brought in 19, 15, and most importantly 17, those traditions are broken.
It can be broken.
No. Therefore, just allow me to continue with that thread for half a minute. If those traditions are broken, what is held hallowed in our society in terms of caste? We made a conscious break and said that we don't want it. We have even gone to the extent of encapsulating let's say, an outlawing untouchability in the Constitution. I don't think there is any constitution in the world which says this shall be an offense as a part of its fundamental right. Therefore, traditions are there to the extent they are there. To the extent they have created the tradition, the institution of marriage, they are there. But at the same time, let us also be alive to the fact that the concept of marriage has evolved, which you yourself said.
No difficulty, Millers. Everything, a lot of evolutions have taken place. Other side has also adverted to them. We have also, Millard, adverted. The point is, all these reforms which have happened are reforms, Millard, which are made by the legislatures in the interest of women and children. And they do not alter, Millard, the fundamental aspect, the core aspect of the social institution of marriage as it exists, namely that it is an institution, it's a marriage, rather not Hindu marriage, they regard it as a sanskar. So, as a sacrament, the fact that now divorce has come in, or the fact that some other modifications have.
Yes, you're right. That is by and large, but
so, but each and every reform, my lord, kindly see 1937.
We are looking at what we understand as the traditional, but there are large parts of society. It's a very diverse Hindu society. That diverse society, even today, and that's why you have Section 29 of the Hindu Marriage Act. You have customary divorce, which is preserved. Therefore, divorce existed in many communities.
Yes.
The diversity is there. That diversity we cannot.
Correct. So, therefore, what I submit is that the core aspect, what is the core aspect of that marriage? You may provide for maintenance, you may have alimonies, you may have divorce on certain grounds, you may provide that there will be intercaste marriages, but ultimately the marriages remained heterosexual marriages. And number two,
Mr. Dwivedi, there are certain, to state at the extreme that there is no fundamental right to marry under the Constitution would be far-fetched. what are the core incidents of marriage? If you look at the core incidents of marriage or the core elements of marriage, not the incidents, I made a mistake. What are the core, what is the core content of marriage? Or what are the constituent elements of marriage? Just one second. If you look at each of these constituent elements, each of them is protected by constitutional values. I'm not saying 21 necessarily, but constitutional values. The preambular values read with 14 and 21. 1. Marriage itself postulates the right to cohabit, right? Of two individuals to cohabit together. 2. Marriage accompanies with it the notion of a family, the existence of a family unit, because the two people who come together in a marriage constitute family. Again, something which directly owes its existence or recognition to the constitutional values. 3. To bolster your submission, we must take that into account also. Marriage has procreation as a very important ingredient of marriage. Though equally we must be cognizant of the fact that the validity or the legality or the social acceptability of marriage is not conditional only on procreation, for the reason that people may not want to have children. People may not be in a position, have the ability to have children, or they may get married at an age when they cannot have children. But we therefore take your point that procreation is a significant facet of marriage. There's no denying the fact, subject to these caveats. 4, marriage in a significant way is exclusionary of all others. Two people who come together in a marriage or want to cohabit together are entitled to exclude everybody else from that area of marriage. No third member of society can say that, well, I want to share in the same relationship which you have with one of you in the marriage. It's exclusionary of others. And 5, which is equally important, just I gave you that thing about procreation, which is social acceptance of the existence of marriage. And social acceptance is then not just confined to that individual, but to the how society itself looks at that institution. Now, having said that, there cannot be any denial of the fact that the state has a legitimate interest in regulating marriage. Undoubtedly. Therefore, the state that's how the state regulates the forms in which you can enter into marriage. The state regulates how many people you can enter into a marriage when you have a subsisting marriage. The laws against bigamy, for instance. The state has a variety of other interests so that it regulates various facets of marriage. But we must therefore accept as a basic proposition that marriage itself is something which is entitled to constitutional protection, and it is not just a matter of statutory recognition. So once we cross that threshold, then we enter into the next level, which is the contested issue here. Is heterosexuality an intrinsic or core constituent element of the institution of marriage? Your submission is that as marriage has evolved, and even today, whether it has heterosexuality has social acceptance or not, is one thing which regulates the state's interest, because the state has a legitimate interest in regulating in marriage, and therefore it may say that I'll not recognize anything beyond a heterosexual relationship for the purposes of marriage. That's your contention.
No, so may I respond on this?
I just want to add something. Actually,
Yes.
the Chief Justice has, I had written something and the Chief Justice has virtually echoed the same thing, but I put it slightly differently.
Yes, ma'am.
I'll just read it out. What is the content? After all, what is a marriage to each other? One is to society. What a marriage to each other, each spouse, they decide what that marriage means to them. So what is the content of a marriage is defined voluntarily by the parties. That is the spouses. They decide, number one, whether to have and raise children, the procreation part. It is entirely their choice. Of course, there are social pressures. We are all aware of it. But ultimately, at the core of it, whether I will have child or both of us will have children or not is our autonomous decision. There may be marriages where parties may not live together. There is no cohabitation in that sense. Both are working. They may be meeting each other once or twice or 5 times or 6 times as they choose. So the concept of cohabitation. There may be no matrimonial home in the traditional sense. Marriages may not have any element or varying degrees of physical or sexual relationship. Now, therefore, as to what is the content, context, or cultural central to a marriage depends ultimately upon the participating, spouses. Is that right?
No. With great respect, no.
So you mean to say that if people... No,
this
please, I'm looking at the voluntary part. I'm not looking at the...
Yes, I appreciate it. I appreciate what falls from my Lord. But that's the great debate which has been going on ever since the time of Kant and Hegel, my lords. Kant said, this is pure contract.
And keep the heterosexual element outside. We are not on that at all right now.
No, that's very fundamental. We can't leave it aside.
No. We are not saying that that is not relevant. We are saying we are testing the core proposition in regard to the content of a marriage.
Because one view is globally prevailing that some say that marriage is simply a contract. It's up to the parties to define, my lord, what marriage is. Marriage becomes a fluid concept completely, my lords, and that's one concept. And that, my lord, what are the consequences of this, my lord? I'll show to your lordship, my lord, by when I read the Nussbaum's article, my lord. She goes up to saying that then you will even have to knock down the prohibited degrees. She says that the state will have to provide justification in the court, my lord, why these prohibited degrees, my lord, cannot be. The health aspect, etc., has been knocked down scientifically. So therefore, knock down prohibited degrees. She even goes to the extent of saying there are 2 pages I'll like to read. Then they can, why not brother and sister can marry?
But that is not, that doesn't pose a constitutional problem to us because that's not.
No,
No, just a second. There you recognize the legitimate interest to the state to regulate. Now, what we are trying
where do we stop? Legitimate, because state has to come and justify why we are banning prohibiting marriage between brothers and sisters.
Of course.
Mr. Dwivedi, it's not as absurd as that, with due respect, because I think in all societies, barring a few, these prohibited degrees of relationship exist in some manner or the other. Age restrictions exist.
So, again, we go back to the history, etc., and then see, my lord, that in Muslims it's a different...
Something even more fundamental. There's something more fundamental. Apart from blood relationship, there is marriage relationship. For instance, sisters-in-law, brothers-in-law. Why is that relationship? Why is that prohibited? There is perhaps a very deep-rooted, public interest in that.
Of course, there is.
That is of some kind of order.
Yes.
Orderliness. So all these are legitimate statements.
But therefore, the state has a legitimate interest to find out, Lord, what is that order, Lord, which is to prevail in the society, given society.
Mr. Dwivedi, that is not being questioned.
So I'm saying that if you treat this marriage as a fluid concept, which individuals in the 2 spouses are to define for themselves what it is, we don't need any law, etc. Then each couple will be deciding, Lord, what marriage has meaning for them.
I didn't mean that no law. I said there is a law. There is a law. I'm talking even of heterosexual. Nobody is compelled to have children. Nobody is compelled to live together.
Lord, that's the greatest of difference, I say. It is one thing that some couples, heterosexual couples, may decide not to produce. Some couples may marry and may want to, but they are unable to produce because of infertility, of medical reasons, biological reasons.
Go outside the precincts of this building and some of these complexes. You see construction workers, you see migrants who are away from their houses most part of the year. They go back barely for 15, 20 days. What is that family life? What is cohabitation for them?
Well, so we are on the aspect of marriage. Family life will vary from case to case, but marriage will not. With great respect, my lord, marriage cannot be made so fluid, my lords, so undefined. Marriage has the core purpose, as I was submitting, my lord, when your lordship put this query to me, is to bring about a unity of man and woman, my lord, for a social purpose. Because society needs to perpetuate itself. The race needs to perpetuate itself. Some may not produce, some may be infertile. These don't decide. The generality is that our population has grown from 44 crores, my lord, to 1.4 billion today, my lord, it's not because of certain people, some who did not decide to produce or were unable. We have reached here because, in generality, people want to come together, they want to cohabit, they want to, my lord, engage in sex, not merely for pleasure, not merely, my lord, for taking care of each other, but for building a family of their own, something out of their own body and flesh. It's all right, some people can adopt. These are exceptions. But the real thing is that we all want our own child and we try for it. We want it. That's how the family is built up. That's how the family, the child who comes into being, we build the relation, my lord, with the relatives. So our concept is different. Take any religion.
Mr. D.Y, if you therefore formulate and articulate the core content of a marriage, how would you do that?
Core content is the coming together of a man and a woman as commanded, as even Bible says, when Adam and Eve were there, that they blessed them for happiness and say, go be fruitful and multiply.
So therefore,
Every religion says procreation.
But definition is that procreation is the definition of marriage.
This society cannot survive. And so look at the problem faced by China and Japan, and today it is being said, my lord, by statistically that world is facing the problem of aging. We can't have IVF, my lord, and adoptions. In fact, adoption, what is adoption, my lord? Some heterosexual union has produced some children, my lord, maybe an orphan, and you adopt. What is IVF, my lord, and surrogacy? My lord, it's coming together of an egg and a sperm, my lord, together to produce a zygote. So ultimately, your family, your efforts to wanting to build something is dependent upon a heterosexual union. That's the fundamental truth. That's the most essential law of nature. That's the cosmic unity. And the society, my lord, cannot survive. Nations cannot be. What is national integrity, my lord, if this society grows old and there are no children? So producing children, bearing and rearing children, we don't want to go to the America way. Maybe there are, again, point out some families here, my lord, who are impressed by that, and where children leave the families at a young age and they are on their own. So everything is not beautiful there, my lord. And I have a very strong criticism of Justice Kennedy's judgment, Justice Sachs' judgment, and Nussbaum, Professor Nussbaum. They treat marriage as a pure and simple contract, my lord. It's not a pure and simple contract. It's the most sacred phenomena, my lord, on earth, and not confined to human beings, my lord, but to other species, plants, and so on.
So when you talk of right to marriage, which is what you were referring to, so marriage in any case transcends the constitution. It is not looking for its sanctity within the framework of a constitution, having predated it by several decades, years, centuries. So when you...
And as your lordship said, my lord, that the constitution enables the legislature to regulate. Over the course of years, we find development of society, my lord, we find certain things which were good at one point of time are no more good. We today want equality within the family. So that's one more change. Bigamy, again, is a protection. These are all laws which are protected under Article 15.3. 15.1 doesn't affect it. 15.3 commands the state to make special provisions for women and children. Bigamy is to protect women. Maintenance is to protect them. Alimony is to protect them. So therefore, all these laws which are being made, our rights are not, the heterosexual marriages don't depend upon this. No constitution can take it away. I will put it like that. It's a natural right.
That's right.
By virtue of our being human beings. To deny that right means to let the nation die. That's the importance of this. And that's what Chief Justice Roberts in his dissenting judgments emphasized. And Justice Sachs in his judgment in 4 says, my lord, that this is not the essential characteristic of marriage. That's how the underpinning, two underpinnings. It's a pure, simple contract dependent upon two individuals, and secondly, my lord, it's not essential characteristic. I am therefore addressing your lordships not to follow the path of Oberge Fell and 4A, my lords. It's the path. They make a declaration. One was, my lord, to insert it. We have already made a submission, my lord, that SMA, my lord, you can't, it's not possible to insert by altering. And the other is not to, my lord, the other course of action would be, my lord, that, all right, make a declaration that they are entitled to marriage at par with heterosexuals, and therefore, and leave it to the parliament. That was one plea by Mr. Viswanathan. So I am dissuading your lordships, my lords, from making any declaration in that context. Because those two judgments, of one is majority, one is unanimous, both are fallacious. Their underpinnings are completely wrong. In India, we don't treat marriage, my lord, as a simple, pure, and merely because there is a consent. Even, my lord, I have annexed in the recent compilation, Faizi's, my lord, Muslim law. He was an ambassador to Egypt from 48 to 52, and then vice chancellor of the Jawaharlal of the Jammu and Kashmir University. And he has written, my lord, that it's not, even there, this concept that it is pure contract is incorrect. You need a Qazi, my lord, presence. You need to recite verses of Quran, and therefore, so it's a mix. Something like seniority come merit and merit come seniority. My lord, in Hindus, it is sacrament plus contract because some consent is obviously implied. If that is to be treated as contract. And that is where, my lord, Hegel comes in, and Hegel says, criticizes very sharply and says it is shameful for Kant to say that it is a pure contract. And he applies the principles of contract and says that contract involves parting and exchange of externalities. When marriage happens, Lord, there is no exchange of externalities, no promise and acceptance in the sense of Indian Contract Act. So yes, consent is there. Both couples agree. If that is said to be a contractual element, yes. But it's not a contract in that sense. And the two judgments treat it as a contract. These are essential things. Why we treat it as a contract? Why the religions, all religions, even though they are in conflict with each other on so many things, yet all of them regard not the homosexual relation as a sin. Your lordships have declared it to be not a crime. But what about that, lords?
But the moment you say that it is not just a matter of mere contract, but there's an element of a sacrament, which is again a fundamental precept of our law, at least insofar as Hindu marriages are concerned.
That these are not precept of custom and
undoubtedly that a marriage is not. I mean, that's the first thing which we learn when you learn the sense of Hindu law.
Yes.
But marriage is not merely a matter of contract; it's a matter of a sacrament.
Sacrament.
Once you accept the fact that it's not a matter of a pure contract, but it's a matter of a sacrament, then it's a sacrament which is also impressed with a constitutional character.
So I have no issues. Your lordship may find it located somewhere, but it doesn't depend on that. Your lordship may find its continuance there. What was existing up till 1950, by the coming of the Constitution, is not transformed into something which is by virtue of the Constitution.
That can be said of anything else.
Yes.
Everything else.
Absolutely.
See,
it's not that we didn't exist as a society and the Constitution switched us on. No.
And that's the basis on which we overruled ADM Jabalpur when we dealt with ADM Jabalpur in Puttaswamy. We said that the fundamental fallacy of ADM Jabalpur was that if Article 21 is suspended during the period of an emergency, that does not suspend your right to life. Because your right to life does not owe its existence to the Constitution. It's a recognition by the Constitution. Therefore, the power to suspend 21 will not suspend your right to life. That was the whole basis.
I have no problem.
Right. Now, therefore, once you say that, well, marriage is a sacrament, then you have to accept that marriage as a sacrament traces its origin to 25, therefore.
Because my submission doesn't turn on this acceptance. Your Lordship may locate it. I have no issues.
Right.
Your Lordship may treat it as part of life itself. I mean, if that is so fundamental, the right to life and personal liberty, so right to life itself will be marriage.
There is a fundamental right to marry within the meaning of the Constitution.
So right to life itself
But
is
we are
marriage.
only joining issue with you that there is no fundamental right to marry.
No, I
But
never.
you began by saying that there is no fundamental.
No,
right to marry, which is really
thrust,
constitutionally
I'm sorry,
informed.
because my thrust is been that there is no equality. Don't make a declaration that the marriage which is to be declared.
In other words, in terms of constitutional, let's say, precept, there is a right to marry. In the sense that it is can be confined to heterosexual. But there is no marriage outside of that. There is no right to marry outside. So there
In
is
that sense,
and then everything else.
It is up to the parliament. If the parliament wants to create artificial definitions and declare it, fine.
For instance, there was no prohibition of bigamy in Hindu marriage. So it was brought
Came in 56 for the first time.
For that marriage matter, there was no concept of divorce. As you say, sacrament, it is still sacrament, and yet there is divorce. Correct? It is still a sacrament among Catholics even now. And yet, if they want any one of them, they go into that and get divorced. So Parliament has that, overriding whatever
That's right.
authority.
They can define marriage, redefine marriage, or create a separate law.
Exactly.
Define their relationship, my lord, in some different manner as many other countries have done.
There's no quarrel about that.
That's true.
It's ultimately in that. If it has to be, ultimately Parliament may have to do.
Out of 195 countries, only 44 countries have recognized the same sex. Maybe less.
And Mr. Dwivedi, then it leads us to one other issue, which is that, assuming that you are right for a moment, that it is open to the state in the exercise of its legitimate interest, either to recognize a broader notion of marriage which goes beyond heterosexuality, or to confine it to heterosexuality. The state has a legitimate interest in saying that we will define marriage in such a way as would promote vital societal interests, including social acceptability or the stability of the social order. Equally, even if you were to concede that, there may be an alternative formulation. And that alternative formulation would be that apart from the element of heterosexuality, there may be other elements of that associational relationship which to a certain extent must find protection within our law, even if it were to be short of marriage, even if you were to accept your point.
What recognition, my lord, if your lordships are contemplating some sort of recognition from the state to that relationship is essential in order to protect, afford protection to their relationship of love and affection, etc., family or adoptions or some other civil benefits. It's ultimately up to the parliament to decide what sort of recognition is to be given, to what extent parity needs to be given. I have at page 58, if your lordship will turn to I have set out at least 10 aspects of recognition which will have to be born in, and only Parliament can do it. Just look at page 58, if I'll just
Mr. Dwivedi, again, what you are saying is not something which is lacking absolutely in substance. There is a germ of substance in what you say. But equally, there may be, it's a more nuanced or a layered argument. One is sort of a constitutional recognition of the components of an associational relationship short of marriage. Two, the administrative or civic incidents of that relationship. And three, legislative recognition. Legislative recognition, legislative regulation, legislative acceptance undoubtedly has to emanate from Parliament. no question about it. Two, the administrative or civic consequences of a relationship, which the Solicitor General said that we are, obviously the government has taken the first step forward by saying that the government is going to constitute a committee chaired by the Cabinet Secretary. Second, but even more fundamentally, in some ways, and not so fundamental because ultimately it has to see progress on the ground, which is how do you define and how do you give meaning to the content of constitutional values? So even assuming that we accept your submission on the legitimacy of marriage as a social institution, the stability of the order, the legitimate interest of the state in protecting the concept of marriage as a heterosexual relationship, or deciding to what extent you will also dilute that concept, it's a matter for the state's legitimate interest and parliament to regulate. Equally, there is, even in this area that we are debating, some element of constitutional jurisprudence left for the court to evolve.
Well, sir, with great respects, the court will not be issuing a declaration which is amorphous, vague. Some sort of recognition needs to be given. I mean, a declaration emanating from the lordships has to be concrete and definite, which results in something positive straight away in their favor.
Well,
Else,
is it that something, are we in a society, a constitutional society, and we are now approaching our 75th anniversary? Are we in a state where we say that a declaration by the state, by one of the co-equal wings, which is tasked with interpreting the constitution? I am not
Yes.
saying exclusively, because other wings also are entitled to. When it says that this is it, and beyond that it will not say, it cannot say, because it cannot implement it.
And we are
Right?
conscious of the fact that we cannot tread into the legislative domain.
There are limits.
So once we say that, does it not have its own force? Are we trained? Let me complete. Let me just complete.
Sorry.
Is common law seeped into our bones to this extent that everything that we say needs to be executed through contempt or through some execution proceeding? Is it not sufficient that the court says that this is the state of affairs? And that's out there for the people, for the parliament, and other branches of governance, including constitutional branches of governance. And I'm not talking of only the constitutionally recognized branches of governance, the society at large, that this is the state of affairs. How it is assimilated is not up to us.
I'm certainly not saying that lordships jurisdictions to make an
No,
appropriate
I'm taking
declaration is not there.
Yes,
That's not
I'm taking it beyond the writ of mandamus. I'm just taking it.
What I'm requesting and beseeching your lordships is that please do not issue a amorphous, vague, too general a declaration which has no meaning.
But take the case of privacy, right? We located privacy in constitutional precepts, but we were conscious of the fact that if we have to implement privacy in the concept of, say, informational privacy or data privacy, we can't do it ourselves. It has to have a legislative backing, and therefore we left it to Parliament to legislate. But Mr. Dwivedi, the very act of the court having granted a certain degree of legitimacy, constitutional legitimacy to privacy, has a very vital role to play in society.
No, but that was not a general exercise because your lordships had an Aadhaar Act in front.
No.
When
it came to the 9 judges, there was no such.
It was independent.
What was argued? You are aware.
9 judges reference came from that only.
Correct, maybe, but then it was an abstract reference.
Because Mr. Rohatgi argued that there is no right to privacy.
The only question was privacy is there or not.
But then it's a wider concept now. There is no law. Even
9
today, there is no law.
9 judges' judgment did not involve any declaration for the purposes of Parliament to do something.
All right, I'll go back. What did 11 judges do? 11 judges did not have a statute before them. Now, Mr. Sibbal is there.
No, they didn't.
There is no statute which has been invalidated. There was no statutory model.
No, it was a reference in a pending proceeding. With great respect, certain questions are every day referred.
So what is the content of 30?
Different.
Mr. Dwivedi also argued. We all know that. It was only argued what is the content of 30. was in the abstract.
No,
Why you're finding it difficult? What we are talking about, both Chief Justice and Justice Bhat is talking about, if there is a right, it's a recognition of a right. The order of a court is in the context of recognizing the existence of a right. It's thereafter for the legislature. Court might not be able to do or take up any executive action to implementing it.
so
Once there is a recognition and court stops there, it is thereafter for the
so
executive
that's
to take it
precisely
up.
where I'm, my lord,
And it's
engaging
one of
in-
the most important and
No, I appreciate,
accepted
my lord, but
function of a
this is
court to give a
precisely where I'm
recognition.
engaging in this debate, my lord, is that when it comes to recognition of a right, then this is a sphere. What sort of recognition your lordships will be providing?
Absolutely, you're right.
That's the
Now, let me just state 10
That's
points. my lord.
exactly what we are also deliberating on.
matter.
We are sort of introspecting at this stage. We are now almost towards this last third of the arguments. That's why we sort
So
of,
in fact, that's one of
we are
the
also in a
core
state of
functions the court.
mental
No, I appreciate.
churning.
It's important, my lord, for such debates to happen, and therefore, my lord, I'm requesting your lordship just to listen to this, my lord. Now, if your lordship wants to, sorry, my lordship.
No, please,
Go ahead, go ahead.
please.
If your lordship is considering, hypothetically, I'm taking.
And Mr. Dwivedi, a lot of what we say to you is not only meant for you, it's also meant for the other side.
My lords, by now, my lords,
You are fully
at the
aware.
back end of our careers, my lord, we are aware of all this, my lords.
You're conscious of that as much as we are. After long experience at the bar.
That's how it is.
That's how it
Quite
is.
learning a lesson from it.
churning process.
Yeah, of
And
course,
I
my lord.
think in a way, we, all of us here are privileged to
In
go through
fact,
this exercise of the mind.
One important aspect of this proceedings is, my lord, that there is churning in the society. People are,
Right.
because of this debate, there is,
Absolutely.
and because of the live streaming, so in different corners of the country, people are thinking about it.
There
And
is
there
a,
are, my lord,
Mr. Dwivedi,
reactions.
so many which ways actually. The live streaming of court proceedings has really taken that our court absolutely
different
to
level.
the homes and to the hearts of common citizens. And I think that's part of the process. I
The
mean,
only thing is that our debate happens in English language, and in the villages, etc., people will not be able to follow, my lord. And the language problem in India is very complex. So,
but you'll be surprised. We are working even on that, Mr. Dwivedi. Even that is not lost to the Supreme Court on its administrative side.
Live audio
We are
translation.
working on this. You see that transcript which you have there?
it's being
We're
translated.
now trying to use technology to ensure that the live streaming content can be
Yes, immediately.
simultaneously made available in
That's
languages
great.
which the citizen can
In
follow.
fact, technology now allows,
Of course.
if you are speaking in English,
Subtitles.
Speech to text.
simultaneously be heard in Japanese
Yes, correct.
without a translation.
We have it.
It's speech to text.
Mr. Sibal.
Mr. Sibal,
Mr.
it's
Sibal,
speech
it
to
is
text.
right.
Telugu,
Yeah, or speech to speech as well.
already.
Not only it's available,
Yes.
it's very much available.
And that's the beauty of it.
That's the beauty.
We must put it
Basically, Millers, we are in the midst of a tectonic shift in societal values. Where we recognize it, where we stop is the issue before the court.
Absolutely.
That's the issue.
So there are 10 aspects, my lord, which will arise.
Now, Mr. Dwivedi, as the
page 50.
as the head of the family, I have to now hurry you along. We are in the thick of debate with you, but we need to now just hurry along so we get everybody else
So
a chance.
just let me just.
Yes. Now, just 10 points if you can formulate so that we can then take it up.
Sir,
Yes, you have
page
put it down.
That's what you are saying, D9, right?
Yeah.
Page
So let's
58,
quickly look at it and then
page
we'll wrap up.
58.
Page 58. No?
D9. D9.
Yes.
D9.
D9. So there are various aspects of recognition, my lord, and therefore I am submitting, my lord, that this has to be left to Parliament, my lord. It can be debated there only in the legislatures. So many aspects are required. And unless all of these enter into your lordship's consideration and some declaration comes, my lord, which measures all these.
Let's see D9.
The claim for recognition gives rise to several questions. That is, what sort of recognition needs to be given? What form of recognition should be given? Should the recognition be given by inclusion in an existing law or means of a separate law? Should the recognition be given at par with heterosexual marriages? To what extent parity needs to be given? Should parity be given at one go or in phases? What should be the spacing of phases? What will be the repercussion of granting par with either heterosexual marriages or transgenders? Determination of whether a majority of same-sex relations and transgenders desire particular recognition with all consequences. Whether the society is sufficiently ready to accept the particular kind of recognition to be given.
Thank you, Mr. Dwivedi. Can we now wrap up, Mr. Dwivedi? I think you've made your point on this.
Now, on 21, Mr. Rohtegi said.
Where is your 21 argument, Mr. So we can just quickly run through that.
D10.
Well, just a word about Article 14, where I was, when this Lordships put questions to me. And that is not that.
Mr. Dwivedi, why don't you do this? You are right, we interrupted you. In 2 minutes, you can now wrap up your Article 14 arguments. We have the overall perspective so that you can just
I'll
put it together and
each one of them.
Page 32, Chief.
On Article 14. Drawn attention to two aspects, in addition to what has already been submitted by the learned Solicitor General. The first is that when this Act, Special Marriage Act, was made in 1954 and the other codifications, at that time, there could be no discrimination at all because of existence of 377, which came to be struck down much later. So at that time, when the Parliament was confining itself to making certain regulatory measures, codifications with respect to heterosexual marriages alone, there could be no contention raised that at that juncture, my lord, it was, the only question will be, my lord, what has happened subsequently is only Navtej which has decriminalized, which comes, my lord, now, 4 years back. Is the consequence of this change such that these laws or any of them become discriminatory and violative of Article 14 now? There are cases where Lordship said that a law may be good when made, but subsequently some supervening change may have happened, my lord, which may result in its becoming discriminatory. So it cannot be, my lord, this law immediately on a declaration in Navtej results in these legislations or some of them becoming discriminatory and therefore requiring, my lord, whether it should be altered or not. Because the question of alteration arises only if this has become discriminatory. The second aspect which I wish to submit is that in view of the core idea of marriage which I have submitted before your lordships, in view of the immense continuity, my lord, the enormous continuity of these customs, etc., even today, it cannot be said that this has become discriminatory because these laws have not been amended to accommodate them. So the question of knocking down this does not arise. Particularly keeping in mind, my lord, that Parliament is fully entitled not to make a comprehensive legislation. After decriminalization, there has to be a process. How long it will be or not, one doesn't know. It is for the Parliament to assess and decide when to come out with what law. It cannot be said that now this judgment, Navtej has come, so within 4 years have passed, nothing has been done, and so now make insertions, amendments. Now at page 42, my lord, is Article 15. My respectful submission is, my lord, that 15.1 doesn't have any impact because most of the regulatory laws and the substance of them is to provide protection to women and children. And it is protected, therefore, by Article 15(3). That's one. The second is, my lord, at page 43, in Indra Sahni's judgment, the majority view emphasizing the presence of the word only. I have extracted that portion at page 43. If your lordship will have the last 4 lines, when in such circumstances provision is made for reservations, for example, on the basis of caste, it is not a reservation in favor of the caste as caste, but in favor of a class or social group which has been discriminated against. And discrimination cannot be eliminated otherwise. What the Constitution forbids is discrimination within court only on the basis of caste, race, etc. However, when the caste also happens to be a social group which is backward or socially and educationally backward or a weaker section, the discriminatory treatment in its favor is not only on the basis of caste. So therefore the word...
That goes as far as it goes. In that
Yes.
context, it's 100% right. But there can be other shades to this only. Supposing you are while employing someone, you say you belong to, let's say, Uttarakhand, and therefore I'll not employ you. And say you also there are other factors.
All I'm saying is that the word only therefore has to be established. If it is only on the ground of region or religion or
putting
something...
it the other way, Mr. Dwivedi, this only has to mean something else, in my opinion. Of course, I'm speaking against the grain because Nargesh Mirza and other previous judges only cannot mean that these proscribed ground can also be there plus others. Can you say while employing, I'm not talking of reservation, that somebody is an ST or an
it
ST.
cannot be any plus plus. Any insignificant plus plus.
Anything
that
else,
Justice Chandrachud
I
has
said that
said.
in Navtej.
In Navtej, your lordship
Also
has
the
said.
Army Women's Matter.
By way of
Yes.
emphasis.
So I'm not meaning that. Then any insignificant plus something.
So discrimination otherwise on the ground of gender will be valid,
but
so long as it is a discrimination on gender and some other attributes. That's not how you interpret Article 50.
But if the other attribute is a major one, which is also being factored, then yes, it will have a play. That's what I'm submitting. That's what follows from...
And our theory has gone far beyond, Mr. Dwivedi. Now we have spoken about intersectional discrimination.
Even so, we can't ignore the terminology which has been deployed there of only. It can't be ignored, yes. As far as I'm concerned, I will say that any insignificant or minor plus will not be...
You have to give that content.
Correct.
But the word only has to be given a content which is more compatible with the Constitution as we see it evolve.
But here, proceeding further, my lord, the question is, we are taking note of one sexual orientation. Moving forward, my lord, one sexual orientation which is resulting in the same-sex relationship. But there is the other sexual orientation which is involved in the heterosexual marriages, which I have already elaborated. It's not that is not a sexual orientation. That is also a sexual orientation, particularly when the women are being protected, and is squarely following under 15(3). So that sexual orientation is of coming together for the purposes for a good of the society. The procreative good is a good of the society itself.
That point you have made, Mr.
So, but that's also a sexual orientation.
All right, thank you, Mr. Now, I think we can now go on to Mr. Civil. I think we've given...
just one, my lord, if I may just submit a paper, my lord, about why, my lords... There's 2 pages which I have given to your lordship.
Today?
Yes.
Just have your junior email it also so that it becomes a
I
part
think it has
of
been emailed.
No, just email it to the court master. So it will become a part of our electronic file.
Thank you.
Other side goes.
So Dwivedi, this you have already stressed actually. You have spoken about why Kennedy and Sachs are wrong and why you don't accept Martha Nussbaum's writing. We'll have a look at it, Mr.
Your
Devi.
Lordship may have a look.
Yes.
I'm grateful. Lordship.
Thank you very much, Mr. Devi. Yes, Mr. Sibal.
Won't take too long, will it, sir?